6 justices, 3 dissenters, one ruling that completely rewrote concealed carry law across the entire United States. And here's the problem. Most gun owners in this country still have no idea what that ruling actually gave them. But that's not even the biggest issue right now, because in 2026, that same Supreme Court decision is about to trigger a second shockwave, one that could potentially wipe out every single restriction your state rushed to slap on you after the first ruling landed. And if you don't understand what's coming, you could be caught completely off guard. So let me walk you through this from the ground up, because the story behind this case, and the case that's about to follow it, is one of the most consequential legal battles playing out in America right now. And it directly affects where you can carry, how you can carry, and whether the permit sitting in your wallet actually means anything in the real world. The case that started all of this is called New York State Rifle and Pistol Association versus Bruen. The Supreme Court decided it on June 23, 2022 by a vote of 6-3. And if you hold a concealed carry permit or you've ever thought about getting one, this ruling fundamentally changed the landscape. A lot of people heard the headlines back then. Very few actually understood what the court said and why it matters even more today than it did the day it was handed down. Here's the background. Before Bruen, there were roughly 8 jurisdictions in this country, 7 states plus Washington, D.C., where getting a concealed carry permit was essentially impossible for an ordinary person. We're talking about New York, California, New Jersey, Hawaii, Maryland, Massachusetts, Rhode Island, and D.C. All of these places operated under what's called a may issue system. And in plain English, that means a government official, some bureaucrat sitting behind a desk, got to personally decide whether you had a good enough reason to carry a firearm, not whether you were qualified, not whether you passed every background check and completed every safety course, whether they, in their own subjective judgment, believed your reason was special enough. So you could be a completely law-abiding citizen. You could have a clean record, completed training, done absolutely everything right, and some official in Albany or Trenton could look at your application and say, I don't think your need is sufficient. That was the reality for millions of Americans for decades. Your constitutional right, filtered through someone else's personal opinion. Then the Supreme Court stepped in and said no. 6-3, the court ruled that the Second Amendment protects an individual's right to carry a handgun outside the home for self-defense, and a government official cannot simply veto that right because they personally disagree with your stated reason. The may issue system, as it existed in those states, was declared unconstitutional. But here's where the story takes a turn that most people completely missed, and this is the part that matters most heading into 2026. The Bruen ruling didn't just change New York's permitting system. Because of the way Justice Thomas wrote the majority opinion, it changed the legal test that every court in America must use when evaluating any gun law. Before Bruen, courts used a balancing test, weighing the government's interest against your rights. After Bruen, that test is gone. Now, if the government wants to restrict your Second Amendment rights, they have to prove that the restriction is consistent with America's historical tradition of firearm regulation going all the way back to the founding era. That is a dramatically higher bar, and it has been sending shockwaves through lower courts ever since. Now, quick but important note here. Everything I'm covering is educational information based on publicly available court decisions and legal reporting. This is not legal advice for your specific situation. Gun laws vary wildly from state to state, and a licensed firearms attorney in your jurisdiction is the only person who can give you guidance that actually applies to your circumstances. What I'm doing here is giving you the big picture so you can be informed. All right, back to it. Here's what happened next, and this is the part that set up the battle we're watching unfold right now. After Bruen came down, the states that lost didn't just accept it and move on. They fought back, and they fought back hard. New York passed something called the Concealed Carry Improvement Act just weeks after the ruling. Since they could no longer deny your permit based on vague, subjective reasons, they took a different approach. They created an enormous list of places where your permit simply doesn't apply. Subways, parks, restaurants that serve alcohol, Times Square, most of New York City essentially. They tried to shrink the physical space where your permit actually works down to almost nothing. New Jersey did the same thing. California did the same thing. Maryland did the same thing. They all passed laws creating expansive lists of so-called sensitive places where concealed carry is prohibited, even if you have a valid permit. And these lists got very long, very fast. Think about what that looks like in practice. You finally get your permit after Bruen. You're legal, you're trained, you're responsible, and then you step outside and realize that practically every place you actually go During a normal day, the grocery store, the transit system, the movie theater, the park is on a prohibited list. You have a permit, you just can't use it almost anywhere you actually need it. That was the reality many gun owners found themselves living in after states launched their counterattack against Bruen. And that brings us to right now, because everything I just described, all of that state pushback, is being tested again at the highest court in the land. There is a case currently before the Supreme Court called Wolford versus Lopez, and this case is going to determine whether the states actually got away with their end run around Bruen or whether the court shuts it down. Here's what Wolford is about. After Bruen, Hawaii passed a law saying that if you have a concealed carry permit, you cannot bring your firearm onto any private property that is open to the public, places like restaurants, shopping centers, banks, parking lots, unless the property owner gives you explicit written or verbal permission to carry there. Legal commentators started calling it the vampire rule, because just like the old folklore where a vampire can't cross a threshold unless the homeowner specifically invites them in, you can't enter with your firearm unless you've been expressly welcomed. That's how restrictive it is. Gun owners in Hawaii sued. The case climbed through the courts. The Ninth Circuit upheld Hawaii's law. And then, on October 3rd, 2025, the Supreme Court agreed to hear the case. Oral arguments took place on January 20th, 2026, and they lasted 2 full hours. And here's what virtually every major legal analyst reported after watching those arguments unfold. The conservative majority, all 6 justices appointed by Republican presidents, appeared to side with the gun owners challenging Hawaii's law. Chief Justice Roberts stated directly that the Second Amendment has been treated as a disfavored right compared to other constitutional protections. Justice Alito told Hawaii's attorney that the state was relegating the Second Amendment to second-class status. Justice Gorsuch questioned why the government gets to redefine property rights in ways that specifically undermine constitutional protections. Justice Kavanaugh essentially argued that if the text of the Second Amendment covers this conduct and there's no historical tradition supporting Hawaii's restriction, that should end the analysis right there. Even the current administration argued against Hawaii in this case, with the government's lawyer warning the justices that if Hawaii prevails, states could theoretically start banning tenants from possessing firearms without their landlord's written consent. Now here's why Wolford matters for you specifically, no matter what state you live in. This is not just a Hawaii problem. Hawaii was simply the test case. New York, New Jersey, California, Maryland, they all passed similar laws after Bruen. They all created lists of privately owned places open to the public where your concealed carry permit doesn't apply. If the Supreme Court strikes down Hawaii's version of this law, every one of those state laws is going to face immediate legal challenges. And we already have a preview of where this is heading. On the very same day, the Supreme Court heard Wolford arguments. A federal appeals court, the Fourth Circuit, which covers Maryland and Virginia, issued its own ruling. A divided panel declared that Maryland's ban on concealed carry on private property open to the public is unconstitutional. And here's the remarkable part. 3 judges on that panel, even the ones who disagreed on other aspects of the case, all agreed on that specific point. That is not a coincidence. The courts are aligning. The legal tide is moving in one clear direction. And this is what most people are getting completely wrong about all of this. They think the Bruen ruling was the finish line. It wasn't. It was the starting gun. The real fight, the one that determines just how far your Second Amendment rights actually extend beyond your front door, is happening right now in 2026. And the outcome of Wolford is going to define the concealed carry landscape for a generation. So here's what you should be doing right now. First, learn your state's current concealed carry laws in detail. Know exactly which places are currently designated as off-limits, because those are the precise locations most likely to be affected when the Wolford ruling comes down. Second, if you're in a state that had a May issue system and hasn't fully updated its permitting process since Bruen, talk to a firearms attorney. Your rights may already be broader than your state is currently acknowledging. Third, pay close attention to what happens between now and late June 2026, because that's when the Wolford decision is expected. When it arrives, the concealed carry map of America may need to be completely redrawn. Let me bring this all together. The 6-3 Bruen ruling was the most significant Second Amendment decision in American history. It established that ordinary, law-abiding Americans have the right to carry a handgun in public for self-defense, and that states cannot block that right by demanding you prove some special need. The states hit back by creating massive lists of places where your permit effectively doesn't work. And now the Supreme Court, with a majority that appears sympathetic to gun owners, is about to decide whether those countermoves pass constitutional muster. Your concealed carry rights are not finished expanding. They are still actively in motion right now, at this very moment. The Wolford decision could land any day between now and the end of June, and when it does, the rules could change fast. One final note. Everything covered here is educational content based on publicly available court decisions and legal reporting. None of this constitutes legal advice for your individual situation. Gun laws differ in every state, and they are changing rapidly. Before you make any decisions about where and how you carry, consult with a licensed firearms attorney in your state. That is the only person qualified to give you advice that applies to your specific circumstances. Stay informed, stay safe. And that's it for today, folks. See you in the next video.